that the proven fact reveals that there was no other stranger or any person that does not stay in that particular house that have an access to the back rooms of this particular house, because that area is only frequented by people who are staying there, and it is a washing line that is in that particular place. So automatically, if the court accepts that there is no other stranger or any person that does not stay there that can be having access to that particular place. This gives credence to the testimony of Justice Naba that the accused admitted that he was the one who laid that particular pave. Based on this particular evidence, I'm bound to accept that the person who laid that uneven paving was no one else but the accused. The evidence on record proves beyond reasonable doubt that the following facts were established. One, that the accused was the last person to see and talk to the deceased. Two, that justice noticed this fresh heap or hump which was unevenly paved with an outside tiles on the same day after the disappearance of the deceased. Three, no other outsider had access to the back of this particular room, indicated in the presence, undetected in the presence of the accused, because the accused was there the whole day. Four, a female skeletonized remains were discovered under the same heap of the soil that justice noticed on the following day of the disappearance of the deceased. Five, lastly, the accused, 2 weeks after the disappearance of the deceased, admitted that he crushed the deceased and admitted and made that particular admission to Zwelakhe Mahlangu, his friend at the time. Taking into account the admissions made by the accused to Zwelakhe Mahlangu, the freshness of the heap of the soil noticed by Justice Ndaba a day after the disappearance of the deceased, and the discovery of the skeletonized female remains, the only inference that this court can draw is that the skeletonized female remains discovered on the 16th of December 2015 at house number 888 Mavundla Street, Pire, Soweto, are those of Palesa Madiba. I want also to add that this particular court reached this particular decision only on the basis of circumstantial evidence. The state did not actually provide anything to this court, either in the form of a DNA result that was conducted by the police that indicates that that particular person is Palesa Madiba. But as I've already stated, that taking into account the evidence and the admissions that were made by the accused to Zwelakhe Mahlangu, the fresh heap or hump of soil that was noticed immediately by Justice Ndaba a day after the disappearance of the deceased, and the discovery of these skeletonized female remains, the only inference that one can come to is that that particular body is the body of Palesa. Those remains are the remains of Palesa Madiba. On the conspectus of the evidence on record, the court finds that the state did succeed to prove beyond reasonable doubt the following. One, that the body found at the above-mentioned house, number 888A, Mavunda Street, Pire, Soweto, is that of Palesa Madiba. Two, that the proven facts and circumstantial evidence proves that the deceased did not leave the house, number 888, Mavunda Street, Pire, on the 12th of August 2013. Three, that the accused is the person that killed the deceased and buried her in a shallow grave behind the room, because there was no any other person that entered that particular room, that particular house on the day in question. That on its own, looking at all this particular information and the circumstances, the proven facts before the court, one is able to put together the dots as to why did the accused actually lie to Adam that he does not have the keys to the house. Automatically, it is very clear that the accused was trying to move Adam away from the house because Adam arrived unexpectedly. Now the question is, what is it that the accused wanted to remove from the house that Adam was not supposed to see? And by lying to Adam that he does not have the key, but the evidence, it was very clear that he testified and told everybody that the deceased left at about 7 o'clock in the morning, and the keys were with him. And Adam, the evidence is that Adam arrived at about 12 o'clock thereafter. Clearly, at that particular stage, the accused had these particular keys with him. Now, clearly, it does not take a rocket scientist to understand why did the accused send Adam away to a particular house and lied about having the key, not having the key in his possessions, whilst it is not true. Coming to the issue of the robbery, the state alleged that the accused robbed the Palesa Madiba of her cell phone because the cell phone was not found. I tended to disagree with the state in respect of the robbery because nobody knows exactly as to under what circumstances that the accused end up with this particular cell phone, and the cell phone was end up in somewhere in Hillbrow, and it was sold to somebody. But the fact is that that particular phone belongs to Palesa. Now the issue is the only person that was with the deceased at the time is the accused. And the inference that one can draw at the conclusion is that it is the accused that took that particular phone to Hillbrow and sold it to somebody. Now clearly, if that is the situation, the question is the state did not tender enough evidence to prove as to the manner in which this cell phone was taken from him. Robbery is when you take somebody's property by force. At this particular stage, I don't know whether the cell phone was taken first before the deceased was injured, or it was taken with the force after the deceased was injured. I'm not 100% sure. But the evidence clearly points out that at an end, that particular cell phone ended up with the accused. I therefore find that the state was not in the position to prove its case beyond reasonable doubt in respect of the robbery, but the court does agree that a charge of theft or theft can actually be the appropriate verdict in respect of count number 2. In respect of count the possession of unlicensed firearm, the accused was in possession of this particular vehicle. A firearm was found in that particular vehicle. The firearm has been proved to be in a good working condition. The accused's defense is that the owner of the vehicle just borrowed him about less than an hour at the time, so trying to indicate to the court that he was not aware of the contents inside this particular vehicle. The owner, Mr. Sylvester, came and testified that the accused took his vehicle about 3 weeks before, and he's been trying to contact the accused. He's been trying to phone the accused. He went to the police to open the case of theft of a motor vehicle, but they could not help him because the vehicle was not registered yet in his name. They wanted the owner to come and the person in whose name the car is registered, and as a result of that could not be able to get hold of the accused. But the fact is that he said and testified that the accused took that vehicle about 2 to 3 weeks before that particular day. Although the two state witnesses, the police officers that stopped the accused, said that the accused told them that he was in possession of this vehicle for the past 6 months, I do agree that there's a contradiction in respect of 6 months as well as 2 weeks, but the contradictions per se does not warrant the court to reject the evidence of the witnesses. The state case of State versus Brainers 1998 is very clear that contradiction per se does not warrant the court to reject the evidence of the witnesses. The court has to look at the number of those particular contradictions and the effect those particular contradictions have on the evidence in totality. I do agree that there was this particular contradictions. I'm of the view that it's not a material contradictions that will warrant this particular court to deviate from the prescribed, or warrant to reject the evidence of the witnesses. The other contradiction is whether the other one police said, he said that he bought the firearm from Kimberly. The other one said it appears that he misunderstood, or what is the situation. He said that the accused said he bought this particular firearm from a person by the name of Kimberly. But what is most important, both of them mentioned something about Kimberly. It might be the other one refer as if accused bought it from Kimberly as a place. The other one says Kimberly is a person. It appears that Kimberly is a person, but I'm of the view that still that does not actually emerge a material contradiction in this particular matter. The firearm was found in possession of the accused. Accused did not have the license to possess that particular firearm, neither have any permission to possess the ammunition, permitted to possess the ammunition. In conclusion, everything equal, of the view, as I've already stated, that the state also did actually prove its case in respect of count number 4 and count number 4, and therefore the court finds the accused can stand up. Therefore, on the basis of the evidence and the reasons that I've already given in respect of the circumstantial evidence that the court has found, the court is of the view that the state has succeeded in proving count number 1 against the accused. Accused is hereby found guilty as charged in respect of count number 1, murder. In respect of count number 2 of robbery, the accused is found guilty of theft. In respect of count number 3, defeating the ends of justice, the accused is found guilty as charged. In respect of count number 4, possession of unlicensed firearm, the accused is found guilty as charged. In respect of count number 5, that is possession of ammunition without a permit, the accused is also found guilty as charged in respect of.